Well, in a major move today, the centre has done a U-turn on the controversial sedition law, saying that it will re-examine it. The government says this has come under orders from the Prime Minister himself. This comes just a day ahead of a crucial Supreme Court hearing on this matter tomorrow. Just 2 days ago, the government had actually defended the colonial-era sedition law and asked the Supreme Court to dismiss the pleas challenging it. So what has brought about this about-turn, and what does that mean? Joining us now to talk about this and other challenges facing the judiciary at this time is Advocate Abhinav Chandrachud, who's also the author of a new biography on one of India's finest constitutional voices, Mr. Soli Sorabjee. Thank you very much, Abhinav Chandrachud, for joining us. Just wanted your first thoughts, on the government stand on the sedition law today. Do you welcome this change of heart?
Oh, absolutely. I mean, any decision by the government to revisit the colonial-era sedition law is something that should be welcomed. Of course, I don't want to speak too soon. We have to see in what way the government is now going to propose changes to the sedition law. Of course, I've been saying for a very long time that even if the government doesn't want to completely do away with sedition, there are various amendments that can be brought about to the law of sedition. For instance, I mean, since 1832 onwards in England, sedition always was a bailable offense. It was always what we would refer to as a non-cognizable offense. It was made a cognizable offense for the first time in 1974. We as independent Indians inflicted this wound on ourselves. In other words, in England in 1832, you needed a warrant from a magistrate in order to investigate a case of sedition. But from 1974 in India, when the Criminal Procedure Code came into being, even without a warrant from a magistrate, the police can investigate a case of sedition. Similarly, a case of sedition in England in 1832 onwards was considered to be bailable. In other words, the moment you were accused of the offense of sedition, you were entitled to be released on bail as a matter of right. Now, the British may have made it non-bailable in India. There's no reason why we should not make it bailable. Of course, in England, sedition has long ceased to be an offense on the statute books. So if there's a complete deletion of sedition from the statute books, that's excellent. The law as it presently stands, of course, is that only a call to violent action on the part of the reader or listener would constitute sedition. But really the manner in which the law of sedition is being used by the government, if you look at the prosecution rates and you look at the conviction rates, you'll see that a very small, a microscopic minority of cases actually result in conviction. So the idea is quite clear. The government is not prosecuting people in order to convict them. The government is prosecuting them in order to silence its critics. I'm not talking about this government. I'm saying any dispensation, any political regime will use a law of this nature to silence its critics. So let's either delete it from the books, or if you don't want to delete it, let's defang it. Let's remove the clause.
Right. I think that's very well put, because we have seen, as you mentioned in what your answer just now, that the Supreme Court actually had put in safeguards in place as far as sedition was concerned, and yet various governments have continued to misuse it. But it's not just true of sedition, Mr. Chandrachud. If we look at other laws as well that are currently on our statute books, are you worried that there is increasingly a tendency to misuse them? For example, you have the UAPA, which is a very tough anti-terror law that is now being used, for instance, against journalists reporting in J&K, for example, or those who took part in the anti-CAA protests, for which the Delhi High Court actually came down very heavily on the police. Are you concerned that other laws too are increasingly being misused?
Well, of course, as a lawyer, I can tell you that the mere possibility that a law will be misused is no reason for that law to completely be done away with or anything of the sort. Of course, the manner in which the law is used can always be gone into by the courts. But we as citizens always have to be very careful, because any government, I'm not talking about this government, I'm not talking about this political dispensation, will always try to ensure that the checks and balances that exist against any powerful regime are weakened. And what are those checks and balances? Number one, the fourth estate in the form of a free press. So the government may try and really threaten journalists or whatever it may be. This has been done for years on end. It's happened decades before as well. The government may try and weaken the states by enacting laws in the form of money bills to ensure that the Rajya Sabha really doesn't have a say. The states don't really have a say in the form of checks and balances. It may try and weaken the independence of the judiciary, because the judiciary constitutes really the greatest check and balance on any powerful government. So we as a citizen really have to be careful, not just in this regime, but in any regime, that really the checks and balances that exist in any constitutional regime are always preserved.
Can I be honest here and say, since you brought up the institution of the media and the judiciary, honestly, a large section of the media, I believe, as a journalist, is not doing its job today and its duty. Do you honestly believe, hand on your heart, that the judiciary is doing the checks and balances that it should when it comes to the executive's excesses?
Well, Nidhi, to tell you honestly, I practice as a lawyer at the Bombay High Court. I'm in the Bombay High Court day in and day out. And I see the way in which the judges of the High Court work from 10:30 in the morning to 7 in the evening every day. And really, with my hand on my heart, I can say that the judiciary is working tirelessly to protect the rights of citizens. It may very well be that there are a few cases that attract a great deal of media attention. Is the system perfect? The answer is no. There's always room for improvement. But I do feel that we have a very vibrant judiciary, and we need to do everything that we can to ensure that the independence of the judiciary is preserved and the judiciary as an institution is strengthened.
All right. Although many would sort of disagree with that at the moment, habeas corpus petitions have been lying unheard for a long time. The Supreme Court hasn't heard the case on electoral bonds, 370 and so much more. But I just wanted your thoughts. You've written this biography on Mr. Sorabjee, and he was such a fine man, Attorney General twice. He was the Solicitor General of India during the emergency. It's a very tough time to defend the government. How do you think he would have been looking at the way things are playing out today with misuse of laws, with the sort of burden on the judiciary as well?
Well, as a historian, I of course, I'm a part-time historian. I'm really a lawyer by profession. I've studied history. And the first lesson that you learn in history is that you don't look at the present time, or you don't try and draw lessons. You don't say, look, what are the lessons that we can learn today from this era in history? But one particularly interesting thing, I really want to say this, is that Mr. Sorabjee, when he was a private lawyer in the 1990s, he saw the trust vote that took place in I believe it was 1996. Vajpayee had lost the trust vote after being in power for 13 days. And of course, Sorabjee used to write articles in the Times of India. He had a column in the Times of India, and he wrote that, of course, he praised Vajpayee. He thought Vajpayee was excellent. But he wrote an article in the Times of India in 1996 saying that the BJP needs to, and I quote, the BJP needs to shed its obsession with demolishing mosques, and it needs to replace Hindutva with Bharatva. Now, the question that I ask you is that, is it conceivable for any government today to reach out to one of its intellectual opponents in this manner and appoint that person as a law officer or give that person any position of power? That's something that really we have to think about today. That here is a person who very strongly criticized the ideology of the government, and that government reached out to that person and made him the highest law officer of the country.
You're right. You're probably not going to ever see that happen in the near future, at least. But Abhinav Chandrachud, thank you very much for joining us on these important issues facing the judiciary today. The sedition law developments, very important. And once again, congratulations on the book on Mr. Soli Sorabjee. Thanks very much.